Hey, hi everybody. Good evening. My name is Sabra Pictuli and I'm a Mi'kmaq lawyer with First Peoples Law. I've been working with Kanesatake now for just over 2 years. Thanks so much for joining us today. It's our final presentation on the draft laws. We have a couple more people joining. It shouldn't take too long. I have time for questions and answers at the end. I do just want to highlight that uh, two other lawyers have been working closely on this file who are not joining us today, but I wanted to give a little bit of a shout out to our senior lawyer, Cynthia Westaway, who's been a lead negotiator on this file, as well as our lawyer, Carrie Young. Before we get into too much detail, a quick agenda, a little bit of an overview. We'll talk a little bit of the purpose of these laws. We'll talk about the 4 laws that will be voted upon on Saturday. Those are the Code of Ethics, the Trespass Law, the Emergency Measures Law, and the Land Protection Law. All of these laws are available, the draft laws, excuse me, are available online for your review. In this presentation, they are the summaries of these laws, so not the actual text. I do encourage everyone to jump on, download them, give them a read over. We'll add the links to the chat for the laws for your easy access. I will also cover registering for One Feather and quickly about next steps, so when the vote is happening, and of course, time for questions and answers. So before we jump into the laws, a quick little overview of the timeline that's brought us here. So I started on this file right at the beginning, and that was in December 2022, which began with some modern governance and best practices workshop that we took place with MCK leadership, management, and staff to introduce governance practices, as well as gathering feedback on best practices, what was being implemented at the governance level. And so that happened between December 2022 and February 2023. From there, in July 2024, and before that to July 2024, we drafted the Kanesatake lawmaking process, and we can drop a link to that chat as well. In July 2024, this past summer, the draft was shared with the community. In November 2024, we partook in a series of community engagements on the draft. And so the draft of the KLMP really outlined a standardization of a lawmaking process. So under Kanesatake inherent authorities, as well as some other mechanisms that I'll jump into the next slide, MCK and Kanesatake has the ability to enact laws, but we wanted to ensure that the process of laws being enacted had some standardization processes, and that's where the KLMP came to be. So again, if you have any questions on the KLMP, jump over to the actual legislation. It is now posted to the First Nation Gazette as well. So the community engagement for the KLMP happened in November 2024. There was a series of sessions just like this during that period of time. And then in February 2025, a few months post consultation, the KLMP was officially passed and it came into effect in February. As a result of the KLMP coming into effect, we then drafted these 4 laws that we heard from community members were a priority, and these 4 laws were then shared in April 2025. We've been partaking in community consultation processes similar to this, both virtual and in person in April and May. And then now the laws are being moved forward through a vote, or determining whether or not they will be moved forward through a ratification vote happening on Saturday, July 19th. So just a quick breakdown of the timeline over the past couple of years that's led us here today. This takes us into a little bit about the legal foundations. So these laws are really about ensuring accountability, safety, and responsible governance. If you open either the KLMP or any of the laws, you'll see in the first substantive page the whereas sections. The whereas sections outline the legal foundations that these laws are able to be passed and upheld by. The first and foremost is inherent rights of the Kanien'kehá:ka. as well as the Constitution Act of 1982, as well as UNDRIP and the UNDRIP Act. So UNDRIP Act in Canada, and of course the Governance Act and the Governance Code, as well as the Indian Act, which is Section 81 and 83, empowers communities to pass bylaws. So those are some of the legal foundations that empower Ganasatake to pass their laws, and you'll see those outlined in the whereas clauses. So I just wanted to give some context to what those whereas clauses say and the impact of the jurisdiction it's giving to Ganasatake to pass these laws. As you'll notice, the custom electoral code is not included in this legal foundation. That is a separate code that specifically and only governs elections. It has nothing to do with the lawmaking process or any laws that are being passed. Jumping into our first law, we have the Code of Ethics. And this is a law that just governs elected leadership. And the intention here is to promote ethical leadership and accountability. It's to inspire new leaders. It's to create and uphold a culture of wellness and safety. And of course, be an example for future generations of Ganagahaga and Ganasatake. Pardon me, there we go. In Section 4 of the Code of Ethics, there is, I think, around, let me see here, 17 different provisions that outline the roles and responsibilities of the elected chiefs. So council members or chiefs, they must represent MCK with integrity and unity. They must be advocates and engage with the community. They must attend meetings and vote in the best interest of Ganasatake. They must lead portfolios based on experience and skills and provide quarterly updates to the community. So this idea of Section 4 is to just codify some of those best governance practices. So to set a minimum standard of the roles and responsibilities that the elected leadership at MCK needs to be upholding. And one part of that is, for example, quarterly reports to the community. So ensuring that there's a standardization of the feedback loop going back to community. Again, like I noted, there is about 17 provisions. In the PowerPoint here, we're just summarizing those 17 provisions. So if you'd like to read them in detail, it is Section 4 of the Code of Ethics law. In Section 5, we have a standards of conduct. So council members shall not engage in, endorse, or permit any form of harassment or discrimination. All members are committed to fostering respectful and inclusive environment. So we have that as number one provision of the standards of conduct. We also have about another 4 provisions that the council members shall act honestly, respectful, and professionally, avoid harassment and discrimination, which we've noted, maintain professionalism on both public platforms and social media, and are bound to follow all laws, policies, and procedures. Now, again, it is nothing groundbreaking or absurd within the Code of Ethics. It's really about codifying some of the practices that are already happening and ensuring that we're setting minimum standards that the chiefs are then upholding in the future. Currently, and across coast to coast, elected leadership members in chiefs and councils are not bound by the same procedures that staff are. So it's important that elected leaders have their own laws or their own code of ethics or their own policies that bound them to a certain standard. And so this is the purpose of this draft law, which is the Code of Ethics. There's also a Section 6, which is a conflict of interest. You're seeing this happen more and more across Turtle Island, really, and the fact that our communities are really unique. We need to be taking in consideration that conflict can look a little bit different having smaller communities, and it's important to define those. So conflict of interest first is defined within the law, and then there's a standard of set here as well. So elected leadership, chiefs and councils must make an effort to avoid situations where personal interests interferes with the duties, and they're also required to disclose conflicts immediately, and if there is a perceived conflict, they must abstain from related votes and discussions on that matter. So for example, If an elected leader, one of their family members, come into council raising an issue, that elected leader would have to abstain from a vote and abstain from partaking in those discussions. And the purpose of defining these conflicts of interest is really to promote transparency, fairness, and again, assigning a certain standard here. So this is section 6 of that policy, if you'd like to take a look at that. Section 7, Section 6 of the law, not policy. Section 7 has disclosure duties. So they must each file with the Director of Human Resources an affidavit prescribed in the following form that outlines any financial interests and business interests that would be a perceived conflict. So there's also a piece here around employment that it is expected that elected leaders dedicate their full time to their leadership role, but employment by MCK is only allowed if they refrain from engaging, employment by MCK is only allowed if open competition is held when there's been fair qualifications and compensations met. So again, there's an expectation that elected leadership is dedicating their full time to the leadership position, and they do not hold a secondary position within the MCK, but it is allowed only if open competition has been held for that position. So there's been a posting, people were able to apply, they would have had to submit an application, and their fair qualifications and compensations have been met. So it's to ensure that there is a standard where elected leadership isn't also self-appointing anyone within leadership to hold a secondary position of employment at MCK. Under disclosure and employment rules, council members must also refrain from engaging in any work or contractual relationship with businesses, organizations, or entities that have interests in matters previously handled by the council. And so that's setting a certain time restraint on how elected leadership should be governing themselves within a 6-month period following the end of the term of the council. So I believe that is under the second section within section 7 that dictates a council member shall refrain from engaging in any work, contractual relationship with business, organizations, or entities that have interests previously handled by the council, including taking employment with companies or organizations that received contracts or funding from the council during their term and subsequently for 6 months period following the end of their term as a council member. And so the effect of that really gives weight to once an election period ends, and if they are no longer elected or they are reelected, regardless, they can't go accept a position at an organization or corporation that was doing business with MCK. So it's preventing any sort of conflict from arising in the future, similar to non-competes that we see in employment law. We also have section 9, use of information and property. This is very standard, but again, wanted to ensure that this is codified for the leadership. So council members must not use confidential MCK information for any personal benefit, and they cannot disclose information without prior authorization, and they cannot abuse access to MCK resources or property. Nothing too complex here, but setting that standard that's usually unwritten, but ensuring it's codified. Under this law, we have a reporting and enforcement provisions. This is section 10, which is the reporting piece, and section 11, which is the penalties. So for reporting, anyone, council member, member of the community, or staff who reasonably believes that a council member is in contravention of this code, so violating this code, they must immediately report the matter to the chair of the Ethics Commission. And so under the Custom Electoral Code, it requires an ethics commission to be formed, which has been formed this past year. So there is an independent ethics commission available. If anyone, council member of the community, or staff reasonably believes that there is a council member violating this code, they report that issue to the chair of the ethics commission. And then the chair of the Ethics Commission investigates the matter and decides whether or not a further investigation is required, and decides whether or not that there was a contravention to this act. Penalties, there are certain penalties under Section 11, which is offenses. So any council member who contravenes this code is guilty of offense and liable either of a fine not exceeding $5,000 and or removal from the MCK in accordance with the Custom Electoral Code. So the Custom Electoral Code sets out some standards of how a council member could be removed. So we are saying they could be fined and or removed. So both or one of the other. I believe that takes us into the second law that we're going to review, which is the trespass law. The Code of Ethics is pretty straightforward. If you want to take a look at that and read over that law, happy to answer any questions at the end. Again, it's a law that just governs the chiefs, the elected leadership, and really just codifies some of the already existing policies and procedures. So moving into the second law, which is the trespass law. This law is a little bit more complicated. Again, welcome you to download the law and read them in detail as I'm providing some summarizations, but I will reference each section. Please pull them up and read them in detail today or into the evenings. And if you have any questions, happy to reach out to communications or myself. So the trespass law is about regulating land access and protecting community health and safety. There's some key definitions. So in each of these laws, you'll see, like I spoke of, you'll see the whereas clauses, and the next section you'll see definitions. It's important for us to be defining those terms because when you see those terms used throughout the law, you'll want to go back and reference what those terms actually mean to understand the full context and extent. So Gunistagi land is the Mohawk territory, including interim land base. Members on the ban list, non-members is not recognized as a member. An occupier, you'll see the term occupier come up quite a bit. They are the legal controller of the premise. So in effect, that could be a leaseholder, an owner of the home, somebody with an authorized document to be the controller of that premise. An authorized person is authorized to enforce that law as appointed by MCK. And you'll see the term officer, which includes police and safety officers. I do want to note we opted to use the term authorized person, and you'll see that in all of the laws, as the authorized person is as appointed by MCK to leave room for your security officers. If, in the immediate future, there's all of a sudden a Gunistagi police force, they would still fall under the authorized person. So whoever's been authorized by the MCK to enforce this law and uphold the law. So what is trespassing? This is section 6. An offense occurs when a person, my Siri on my phone decided to answer what is trespassing. So under section 6, an offense occurs when a person enters or stays on Gunistagi land after being told not to, disobeys oral or written direction to leave, and re-enters after removal or engages in prohibited activity without permission. So what that means is subject to section 4. In section 3, a person who does any of the following is committing an offense to trespass and therefore trespassing, entering onto the land or premise after the occupier or authorized person has given them notice that the entry is prohibited, engages in activity on the land or premise that the person has been given notice from the occupier or authorized person that that's been prohibited, and a person who's been directed either orally or in writing by the occupier of the premise or authorized person to leave or stop engaging and then doesn't leave or stop engaging is therefore trespassing. So we'll talk a little bit more of that. I'll give a little bit of the examples. So there is a defense to trespass. You'll see that in section 4. A person may not be convicted of an offense under section 3 in relation to the premise if that person's action or inaction as applicable to the offense was with consent of the occupier and the MCK or other lawful authority like the police. And so I'll just give you a quick breakdown of an example. So I'm Mi'kmaq. I'm a member of Eel River Bar First Nation in northeastern New Brunswick or Upaganjik. I have an aunt who lives in Gunistagi. So let's say I was visiting my aunt or maybe more so, my aunt had to leave town. She has dogs. She asked if I could go house sit and watch the dogs. I was staying in her house. A neighbor saw me, outside walking the dogs on the property, saw that I was, staying in her house. That neighbor thought that my aunt was out of town, didn't know I was staying there, was concerned, felt like maybe I was trespassing. Let's say they called an authorized person, which, in this instance may be security, called security and said, hey, there's somebody over at, this person's house. I don't think they're supposed to be there. They show up there and go, hey, like, what's your name? And I tell them my name, and they go, why are you here? I think you're trespassing, and that's putting me on notice. So then I'm receiving a notice orally from an authorized person that I'm trespassing, unless I have a defense to trespass, which in that case I do. I go, hi, thank you so much for coming to check. I actually have been given permission, asked to come, dog sit and house sit by my aunt. This is my name. They're able to, verify that information by calling my aunt or so forth. And then therefore I have a defense to trespass. I'm not guilty of trespass. I'm not actually trespassing, even though technically under the definition of trespass, it would be trespassing if I didn't have that permission, right? So if I didn't have a defense. So that's kind of a really simple example of how it would play out in those pieces. Under, I jumped ahead one, excuse me. Under section 5, we have methods of posting or giving notice. So you have to be given notice to be trespassing. For purpose of the definition of the land in subsection 2, signs must be posted so that in daylight under normal weather conditions, you can see this sign. So that would, excuse me. Okay, that would be considered giving notice. So for example, you'll see signs or signs could be posted that you're entering into Ganasatake land, and that's giving notice that you're now entering into Ganasatake land. So if you don't have a right to be in Ganasatake land, or if you're coming into Ganasatake land and getting up to no good, you've already been given notice that you're entering into Ganasatake land. And so, for example, then there isn't a defense if that person is committing a crime on Ganasatake land and security's called and they go, you're trespassing. They can't go, oh, I didn't know it was Ganasatake land. And the idea of having these signs is saying, well, actually, there was a very clear sign as you entered into Ganasatake saying you are now entering into Ganasatake lands. And there was a very clear sign when you were exiting. So they're not able to rely on that defense saying they didn't know it was Ganasatake lands. So that's one example of how signs must be posted. They can also be given orally written signage based, like we just talked about, or text or symbols indicated prohibited activities. So for example, if there was an area that there's no fishing allowed, if you had a sign with a big red circle with an X in the middle that says no fishing, that's considered to be given notice as well. Trespasser identification. So on demand of either the occupier of the premise, so let's say the person that owns this home or an authorized person who has reasonable grounds to believe that that person is in contravention of section 3, so they're trespassing, that person must provide their correct name and address. So if someone who lives in Ganasatake and owns their home in Ganasatake sees somebody's trespassing and they go, hey, you're trespassing, what's your name? And that person goes, to hell with you, I'm not giving you my name, and refuses to give their name, then they are in violation. They are in fact trespassing. They have a duty to identify themselves. So refusal to provide information, their name and address, that could be one offense. Remaining on the land after refusing, second offense. So for example, if the occupier of the home, the owner of the home goes, well, hey, you're trespassing, what's your name? And they go, to hell with you. And you go, you need to leave. And they go, to hell with you. They're staying. They're technically committing 2 offenses. It could be considered offense 1 and offense 2, which means there could be multiple fines involved. That ties nicely into section 7, which is the offenses section. Again, fines up to $5,000, imprisonment up to 2 years less a day, or community service or restitution. So Excuse me, I have a very dry throat today. I'm just going to take a sip of water here. So all the offenses under all of the laws except for the Code of Ethics, so the trespass law, the land protection law, the emergency measures law, they are created under punishable on summary conviction offenses. And so those proceedings take place under Part 27 of the Criminal Code of Canada or the Contraventions Act. And so that's where you're seeing these offenses would be heard by the Court of Quebec or a Justice of the Peace or MCK if they establish their own courts. So you'll see that language under Section 7. Because currently we don't have a Justice of the Peace appointed and we don't have our own courts, it would be heard by the Court of Quebec. And sometimes we receive questions, why wouldn't it be heard by a federal court? And this is because of Part 27 of the Criminal Code. It is a summary conviction, which has the jurisdiction of Quebec, and they have the jurisdiction to hear and try any of those offenses. It is not a federal court jurisdiction, and so that is why we see that. Yes, a fine not greater than $5,000, imprisonments less of up to 2 years less a day. That is the max imprisonment time for a summary conviction. So just a little bit of background and context to where these penalties are coming from. They're coming from what's described as a summary conviction. If you open the laws and look up Section 7, the offense sections are pretty much the same in the 3 laws that I have mentioned. So we'll recommend that you read them thoroughly, and if you have any questions, happy to address any of them. But that is the rationale for being heard by a Court of Quebec. They have the jurisdiction over those summary convictions, which is Part 27 of the Criminal Code. Imprisonment cannot be more than 2 years less a day, and the fines cannot exceed over $5,000. But the caveat here is that each day of an offense is a new charge, which means if you've been asked to leave and issued an offense for trespassing on day 1 and you still refuse to leave by day 2, so let's say you received a $2,000 fine for day 1 of trespassing, you refuse to leave, security comes back for day 2, they can issue you a new charge. It's a new offense as it's a new day. So you could have a $2,000 charge from your day 1, and then you could have another $2,000 charge from your day 2. That takes us into our third law today, which is the emergency measures law. This is actually a fairly simple and straightforward law. It is a proactive law. So I will again give you a summary. Please open the sections and read them in detail if you haven't. This law is designed to protect the community in emergencies or disasters, and this is defined in the law. This is a law where the key definitions or the definition section is very important for you to review, as there's limitations of what could be construed as a disaster or emergency. So disaster means an urgent or critical situation that has resulted or may result in the harm to the safety, health, or welfare of the people, or in widespread damage to the property. Emergency means that there is a present or imminent situation or condition that requires prompt action to prevent harm or damage to the land and or loss or life, harm or damage to the safety, health, welfare, or members. And health and safety is defined as well. It means the state of physical, mental, and social well-being of members. And again, you'll see the term authorized person here used. Just like in all of the other laws, means a person authorized by MCK to exercise power or perform a limited duty under that law. So as you can see, with these definitions, it's not possible to just say anything is a disaster or anything is an emergency. A disaster really means there has to be an urgent or critical situation that has either resulted or may result in real harm. So harm to safety, harm to health, or damage to the land. Similar with emergency, has to be present or imminent, which means it has to be about to happen. That would require a prompt action, so immediate response to prevent that harm or damage. jump over to declaring a state of emergency. So under Section 4, an event of an emergency or disaster, which again has been defined. So there's limited scopes of what an emergency or disaster could be. So in the event of an emergency or disaster or impending emergency or disaster, so something that's about to happen immediately, the MCK by resolution, band council resolution, can declare a state of emergency. So the ability to declare a state of emergency by band council resolution is only possible if there is an imminent emergency or disaster. And to be an emergency or disaster, there has to be a real threat of harm, or there has to have been harm, whether that's to community members or to the land. So you must include in this resolution a description. So description of the emergency or disaster. It can't just be a declaration. It has to say what the emergency or disaster is. It has to say the date it's coming into effect. It has to say the duration. So it cannot be for an unlimited amount of time. It has to have a time limitation within it. And this must be limited to the length of the emergency or the disaster. It also must include the description of the affected areas and the contact information and any emergency actions, which we'll talk about what those could be in a minute. This resolution, this declaration has to be made publicly available immediately, including emails, electronic methods, websites, social media, and notices in the community or band office. So that's just briefly about that. I'll give another example once we get through emergency measures, so the actions that could be taken if there is a declaration. So in Section 4, then declaring a state of emergency, once there's been a declaration that there is a state of emergency, there are a series of emergencies measures under Section 5 to implement emergency measures. They could issue these orders that include regulating or prohibiting travel to from within specified areas, evacuations, directing authorized person to provide essential services, like setting up a hospital or emergency care facilities or emergency rations, regulating and distributions of goods, services, and resources. So again, a ration situation, authorizing payments required to address the emergency or disaster, like payments to establishing a hospital or getting a doctor there or nurses there, addressing or repairing or replacing damaged property belonging to MCK or the lands, and assessing environmental damage and taking steps to mitigate or eliminate that damage. So again, you can read that through in Section 5. As you can imagine, this is a law we're seeing more and more communities adopt as a result of COVID and realizing that there wasn't, an ability to declare a state of emergency within the community, and there wasn't a lot of regulations or codifications of what that would look like if there was an emergency. So this is a very preemptive measure, but as a result of some learned lessons through the emergency during the pandemic. So for example, let's say there was a flash flood, right? Kanesatake is on the river there. If council got word that there's a flash flood warning taking place, they may opt to say that there's a disaster or emergency that's imminent. This flash flood warning is happening now. The waters are supposed to rise tonight. They may opt to make an emergency declaration saying that there is a state of emergency, and they may say, okay, this is the description. There's a flash flood warning. The date is effective as of tonight. The duration will only be for a week. The affected areas is everyone within 100 feet of the water frontage. The contact information is this email, this phone number, and the emergency actions, which comes from here. The emergency actions may say everyone needs to be evacuated if you live within 100 feet of the river. We're setting up emergency shelters, and this is the contact information. So this is how that law is intended to be used. Given the restrictions around emergency and disaster, there's not a lot of room for there to be a state of emergency declared outside of that. It is very restrictive. There has to be some imminent emergency or disaster, which means real and actualized harm to people or the land. So ending an emergency, which is section 6, upon the resolution, so upon the emergency or disaster being dealt with. So using the flood example, it came into effect that day. The flood happened. We were able to get everyone evacuated into the shelters that were set up. It took a week. The duration lasted a week till flood damage was gone. Under the emergency measure orders, they were able to clean up everything, get it all cleaned up. Once that was resolved, then the state of emergency and any emergency measures are also lifted by resolution. They also expire by resolving the emergency or disaster. So on one hand, it can be lifted by resolution. It also can only last as long as the emergency lasts. So those are two real core things in place, that once there's no longer an emergency, the emergency state has ended, and or once there's been a resolution saying the emergency state has ended, it's ended as well. Then we go in here in the offensive section, section 7. Again, you'll see here the same wording that you see in the other laws. This is a strict liability offense. It's governed under Part 27 of the Criminal Code under summary convictions. So there could be fines up to $5,000. So let's say, there was a need for evacuation, and there are, businesses refusing to evacuate, and they're endangering the lives of the members by, overriding or refusing to uphold the state of emergency. They could be issued a fine for, not upholding those emergency measures. Again, this would be tried under the Court of Quebec, being that it's under the provincial jurisdiction and Section 27, Part 27 of the Criminal Code of Canada. So you'll see that language being very similar across the board. Quick summary, it's really about enabling rapid response. It aims to protect people, property, and land, and it emphasizes responsible use of authority by having those really clear and stringent definitions of emergency and disaster. This is an important law to get in place before there's an emergency and disaster. We don't want there to be, any real climate emergency or any real health emergency, and the community not be able to exercise the proper powers to address any impending harm and ensure that safety and wellness is a priority. This takes us to our last law, our fourth law, which is the land protection law. This law is really focused on protecting land, environment, and natural resources. This is another law that has a series of definitions. They are very key. They're a little bit lengthy. I've just put some summaries of these definitions. You'll see the definitions in section 2 of this law. The first definition I want to highlight is contaminant and pollution. Broad definition, it means, or I shouldn't say broad, inclusive definition, it means any solid, liquid, gas, odor, chemical, heat, sound, vibration, radiation, or a combination of these that are directly or indirectly from activities or contexts of a person, which may be harming the environment or ecosystem, interfering with the use and enjoyment of the land, causing serious injury or significant damage to the environment or ecosystem, or be adversely affecting the health, safety, or welfare of people. Could be dumping of any waste, garbage, debris, or similar material outside of a garbage can or authorized bin or area. Dumping, spilling, discharging, releasing, or depositing any substance, liquid, or gas that is noxious, hazardous, polluting, or harmful to human health or the natural environment. So this law is really focused on protecting the land. And there are some, large definitions that take your time, read through, as there's also a number of words that were in the previous definition that are further defined, like ecosystem. It was important to take a broad definition of ecosystem, so any interconnected living systems. Oftentimes we see concerns around ecosystems not including the interconnectedness of our systems. We also have a definition, of habitat, which is spaces where aquatic or wildlife species live. And we have a definition of natural resources, which includes soil, water, and minerals, plants, and etc. So you'll see that there. This law is fairly straightforward. There is a short list of prohibited activities, so the things that are not allowed. It is unlawful to introduce pollutants or contaminants, which was that large definition we went over. So it's unlawful to introduce a pollutant or contaminant and damage the habitat ecosystem or the land. You see that under section 4. It's very direct, subject to any permits. It's an offense to engage in any and all conduct that introduces or has the potential to introduce contaminants or pollution that may or will cause or likely to cause harm, damage, pollution, or other impacts on the lands. So that is the only prohibited activity, which is really just about ensuring the integrity of the land. We do have a note here that all damage really impacts our Section 35 rights, and as Section 35 rights holders, it's important to consider the importance of protecting land and ensuring that we're not introducing contaminants and pollutions, and that the integrity of the land stays, and that is a way to continue to uphold Section 35 rights. This law, there's also some permitting sections. So recognizing that it is a very in-depth definition of what could be causing harm, there is the ability to seek permits. So under section 5, permit section, the MZK may issue permits by resolutions, by Bank Council resolution, to authorize specific activities that would otherwise be prohibited under this law. Such permits, such permits shall be subject to terms and conditions and restrictions that are set by MCK. MCK may revoke or suspend permits by resolution at any time if the permit holder fails to comply with the conditions. So a little bit of the section around permitting. There's the prohibited activities, recognizing that there may be things happening under prohibited activities that would need to continue to happen, such as like garbage collection. There's an ability to have permits to ensure that that's being undertaken to a standard. So these conditions and restrictions are really to mitigate the harm, and the process is fairly simple, so permits are able to be moved forward or revoked in a fairly simple manner. There is also complaints and investigation sections. So recognizing the importance of protecting the integrity of the land, recognizing that there are permits also that could be issued under this law. There's also recognitions of the need for complaints and investigations. Section 6 is the complaint section. So any person could submit a complaint to the MCK. So a member, non-member, a staff member, you could submit a complaint to the MCK, and the complaints can also be submitted anonymously, recognizing the importance of, safety and integrity of the person. But there's some certain standards that what the complaint must include. So the complaint has to include the suspect's information, the activity description, so any known addresses, the area that it's happening, and the location it's happening. Under section 7 is the investigation piece. So the last two arrows on your screen there, those are under the investigation pieces. So where a complaint is submitted under section 6, and the MCK has reason to believe that the offense has been committed under section 4, which was the offense of violating this law, an officer or authorized person may enter in the premise where the alleged offense is to collect evidence, including but not limited to taking photographs of the area, collecting natural resource samples like soil and water, or witness statements. So let's say someone saw there was dumping happening on the powwow grounds. There was an anonymous complaint to the MCK saying, "Hi, I saw so-and-so at 6 p.m. on July 14th dumping XYZ on the powwow grounds." Then the officer or authorized person could then investigate that complaint where there's reasonableness to believe that it warrants an investigation, and they can go and take photographs of the powwow ground and collect soil samples to see if that's happening. So upon receipt of all this evidence, The MCK then determines whether or not an offense was committed under Section 4. Again, you'll start to get really familiar to this offense section. It is, again, a strict liability. Penalties are up to $5,000, punishable under summary conviction, which is Part 27 of the Criminal Code of Canada. It will be heard by the Court of Quebec until we get to the point where we have our own justice of the peace or our own court system, and it'll be heard by the Court of Quebec because it's under provincial jurisdiction, being a summary conviction. A little quick note on some pieces for all the laws. So laws can be repealed or amended via the community process under the Ganastauqui lawmaking process. So once a law has been passed, any changes to that law still have to go through the KLMP. So therefore, it can't just be unilaterally amended post community consultation processes. It has to be amended after additional community consultation processes. Language rights are respected in interpretation, meaning if the laws are challenged and it's not clear within English, the Mohawk language would be used as like a fundamental way to interpret the principles of these laws. Laws remain valid even if parts are invalidated. That's a standard approach. Just saying that if there's, a miswording in one area, it doesn't invalidate the entire law. And this is important to note that once a draft law is passed through one of the mechanisms under the KLMP, and there's 3 or 4 different ways under the KLMP a law can be passed. Once it is passed, it is then only effective once it's been officially publicized on the MCK website and or the First Nation Gazette. And that is really just in place to say that, laws can't be passed in secret and then not publicly accessible or knowledgeable. It wouldn't be very effective in that approach. So it's only effective once it's officially published and available on the website and or the First Nation Gazette, which you can see the KLMP is on the First Nation Gazette. And these laws, if they were to be passed, would also be available on the website and First Nation Gazette. A couple other housekeeping notes. If you haven't already, please go to www.onefeather.ca/nations/Ganasatake. You'll be able to register for important upcoming information, as well as any online voting. We do have online voting for these draft laws specifically. I recognize that it's close to your election date. There is no online voting for the election as that's governed under the Custom Electoral Code. Lawmaking stuff is not governed by the Electoral Code. It is governed by the Ganasatake lawmaking process. And so there is online voting available. It opened July 5th and remains open until July 19th, which is the official voting day. So the voting date will take place at the high school. You'll be able to go vote between 8 a.m. to 8 p.m. You'll see on the notice to vote, which maybe our communications officer will drop the link to the notice to vote, which has the questions outlined for each law. So if you would like to adopt one law and not adopt the other, you have the ability to do so. The questions are asked for each law individually. And you'll see that there will be a yes question to yes adopting the law. There will be a no question that says no, the law requires more community consultation. So for example, you may say, I love the Code of Ethics law. I want to adopt that to ensure that council's bound to this Code of Ethics. And then you say yes to that. Maybe you say no to a different law. You're able to vote individually. So that's fantastic. Another piece on that, just in terms of the voting threshold, if you haven't read through the lawmaking process in depth, would recommend it, but we do have a voting threshold so that the laws require a 20% turnout. So 20% of the community has to vote on these laws, and the majority of those who have voted, as long as it's met that 20%, needs to be in favor for those laws to pass. So even if 20% of the community comes out and everyone votes no, the laws still would not pass. Or if only 10% of the community comes out and everyone votes yes, the laws still do not pass, as it doesn't meet that 20% threshold. So those are just some of the things in place. I'm happy to take any questions, comments. Additional questions or comments can be directed at the communications email or myself, which is spictuli@firstpeopleslaw.com, and I'll drop that into the chat so you have access to that as well. But considering all that, I'd open it up for any questions or comments. You're welcome to use the chat function. I believe for safety precautions, we have everyone's mic and camera blocked to ensure there's still an element of anonymity. So welcome you to put questions in the chat. And thanks so much for joining.
So Saber, the mics are now unmuted, not unmuted, but unblocked. So anybody that wants to ask a question, just please raise your hand so we can make sure that everybody gets to speak in turn. While we wait for that, Saber, I just sent you an email. So for everyone, we do document all comments and interactions that are submitted either via Facebook comments or emails or anything like that. Maybe, I don't know if you want to read it quickly and maybe address it in this recording so that people have access to those answers readily.
Sure, let me open them up. I see Cheryl has a question in the chat as well. Dan, if you'd like to ask first, I think you were in queue first, and then I'll address Cheryl's question. Okay, great. Thanks, Dan. In the meantime, I'll address Cheryl's question. Will these laws be applied retroactively? They will not be applied retroactively, but they will be applied going forward, which means that every day there is a violation of these laws, like toxic dumping, there would be a new offense under that law. Cheryl, I can't speak exactly to the toxic dumping issues, but my understanding is that it's still an ongoing issue, which means there would be an offense under this law. I believe that has not been resolved. I don't think that toxic dumping site has been cleaned up by the people partaking in the toxic dumping who are responsible for the toxic dumping, which means they could be held liable under an offense under the land protection law. Thanks, Dan. I see there's a lot of questions and comments around the land protection and ensuring that there's, land integrity and environmental integrity. I believe this is an ongoing issue, so the laws would be helpful in continuing to enforce that standard. Currently we've gotten into issues of having this toxic dumping piece because of a lack of laws, and the first step in addressing them is putting laws in place so we're able to then work towards enforcement measures, work towards building upon that standard that we're identifying here in the laws. I believe that's a common question from community members is issues around enforcement, and I empathize so much with that. There's a lot of communities moving towards private prosecution. This is also why in the offense section we have the ability to try these issues within the Court of Quebec, recognizing that we may not have the immediate measures to enforce them, but we do have tools like the Court of Quebec to be enforcing these issues after relaying these offenses. So that is private prosecution, which is a mechanism currently and readily available to us. But again, to build up all of these measures, to build up, a standard of enforcement and regulation around toxic dumping, to build up a standard enforcement around police forces and all of these other pieces, the very first step is enacting laws. And this suite of laws came out through, prioritization of from the community, from that we've heard from community members over the last 2 years, being that trespass is a big issue, huge concern around the environmental protection piece, and of course a code of ethics piece, and then the emergency measures piece when there is an imminent emergency. Great point. This also ties back to the term authorized person. We get some feedback that that's a broad term. Who's authorized? What is their authority? So first, any authorized person is limited in their authority to enforcing that specific law that they've been appointed to enforce. So they do not have broad authorization, and they do not have any authorization outside of the scope of the law that they're enforcing. So using the Emergency Measures Act as an example, let's say there's an emergency, we'll go back to the flood. In the emergency measures, in the declaration that there's an emergency, they appoint an authorized person to act as, let's say, a coordinator. So they're authorizing then an emergency coordinator who's then going to coordinate between the Oka Fire Department and the council and all of these emergency measures pieces. This is part of the rationale to having it listed as an authorized person. The authorized person is limited to whatever authority is bound by that law, but it gives some flexibility in recognizing that maybe in the future we do have a fire or police department, so then the authorized person is our fire and police department. But in the interim, maybe we would need to appoint a community health officer, an emergency community health officer, or an expert, infectious disease person as an expert under the authorization piece. So there's some flexibility there, but I do want to just re-emphasize to everyone listening and who will be watching this recording that an authorized person is very much so limited to upholding and enforcing whatever law they've been appointed to uphold and enforce. There's no blind power in that. I see there's just a comment, who is not benefiting from the toxic spinoff or easy money selling our culture and ignoring our original way of life to protect the life givers? I don't have an answer to that, but I do just want to thank you for adding that comment. I think these are important things for us to be thinking about. Is that these laws govern the overarching prohibited activities and what happens if that prohibited activity, there's been an offense, right? So what the offense is. Down the line, there's also additional abilities to prescribe policies once laws are in effect. And I say that because sometimes there's concerns around, well, there's no specific guidance about the permitting. It says anyone can submit a permit to MCK, but where do we submit that request for a permit? Where do we submit our complaint, right? Well, those things will just come out to support the law post the adoption of the law. So the very first step is we have to either adopt these laws and move them forward. And then I'm able to develop those pieces with communications with other teams. We don't want to write into a law saying that the complaint mechanism is going to be on this website link, because what's going to happen is the website link might not work in the future, or it might change, or the website name might change. And then the law, that piece of the law, wouldn't be very valid. So that's why you see more general things like the complaints will be submitted to MCK. Then there will be an additional policy on the complaints process, which will give you distinct direction of where on the website to submit it or what email to submit it to. Those are just little pieces I wanted to address. Additional question, will these laws apply to lots where over 9,000 truckloads of toxic waste are dumped over a year's time? Yes, they would. So any future activities that would be considered an offense under one of these laws could be ticketed or issued an offense. Yeah, these are important comments to hold space for and to think about how, we govern ourselves too. Thank you so much for everyone that's contributed in the chat. I have addressed some of the questions in the email with some just general commentary. Are there any other questions related to these laws that I may be of assistance in addressing? I do want to note that the online voting is available. If you have any concerns around safety in terms of voting for these laws, it is a great mechanism. There's just a comment I'll read. I appreciate the effort. Ganastage is playing catch up on the development of laws, policies, and procedures that define how this community is run. Hope the work continues. Implementing them is going to be interesting. Yes, of course. Definitely up for all of the challenges and excited to the prospect of implementation.
I do see someone else with a question. I'm just going to see if their mic is unmuted.
I'm just asking because I wasn't able to make any texts or any questions. So when is your vote taking place? And where do you get all this stuff? Where have you? I got a few questions. First question is like you said, you guys are doing some type of voting. Where's the voting going to take place?
Great question, Josh. It's going to take place at the high school this Saturday from 8 a.m. to 8 p.m. You're also available to vote earlier as of now if you register online with One Feather, and we'll put all of that in the chat again. And I will just pull up my presentation that I stopped sharing screen just to leave it on as we wrap up.
Where have you guys where's your experience? Is this like the first time you did it, second time, third time? You have experience in this before?
For doing votes?
Doing like creating the laws and all that policy, or that's not you? I'm just chiming in first time.
Yeah, of
So
course. No,
forgive
no,
me.
great questions. I'm a lawyer with First People's Law. I've been a lawyer for 2 years now working on this file. I have clients coast to coast, but I am just one lawyer of about 50 from my firm that exclusively do this type of work. So we
Okay,
only work.
so
So,
you guys all like made oaths to like the government of Canada and everything like that, right?
well, that's a tough one. I'm Mi'kmaq, so I made an oath to a feather, actually.
Do they uphold and respect that? Are
Do
you
I? Yeah,
recognized?
I
No, but
uphold and respect that.
are you recognized from your people for that, like and everything like that? Like, which community are you from?
Yeah, I'm from Eel River Bar First Nations, Upaganjik, so northeastern New Brunswick.
Never been there. I have to check it out. What's it like
Yeah,
living
you
there?
should. Do you know where Listigoch is?
Yeah, we go hunting over
Okay.
there.
So
Got
we're
friends.
20 minutes from Listigoch.
Yeah, I got the Mi'kmaq. They taught me Gamundi and Gijimiji Watch. All kinds of the lovely language you guys carry.
Yeah, same goes to you guys. I went to my undergrad in Concordia in Montreal, and so I spent a lot of time in Mohawk territory, and I think I know probably as much Kaneohage as I do Ilnu or Mi'kmaq. We have close relations now.
I bet. It's all part of the Reconciliation Act.
Yeah, so we definitely, and just to circle back, the law firm that I work with is exclusively works with First Nation communities, and that was a very important part of being a lawyer for me is doing work with our communities, and I work with my community as well, and I'm called in Ontario and I'm called in New Brunswick, and I work with communities from British Columbia, Quebec,
And you
Ontario.
and you've done this before in your community or others?
We haven't done, actually, yes, we've done bylaws, as well as laws. We've done a lot of it. I only do this type of work. So I only do law drafting for communities. This is my favorite type of work. We do it, yeah, we do it a lot. And it's
Okay.
you know a
So what
very
is it exactly you do? Sorry.
No, it's fine. I'm a lawyer, so we do all kinds of different type of law. I work with communities to, uphold their sovereignty, whatever that means to them, implementing laws, policies, procedures, negotiations, specific claims, litigation, pretty much anything that really helps move forward the interest of the communities as a collective and upholding our sovereignty and nation to nation relationship.
Collective. I like that. How was your outcome of it? Did you guys have any backlash? How was your people? Did they like it? Guaranteed you guys must have pros and cons or left and right parties to everything you're doing, just like anything.
My community is very small. So we only have a community of 500 people. So there's some unique challenges when working with a very small community. We definitely have some, family versus family stuff that you have to navigate. We
It's
just
every
had,
community.
like every community, yeah, we just had an election. So we have a new chief and council that came in on June 21st. So they've been in for about a month, and that's been really exciting. We've just gotten organized to do their financial administration law. We're under the First Nations um, Financial Act, so we're doing that right now with them. Yeah, we're doing lots of things. We've just repealed a couple laws that they put in place prior to me being their lawyer. So we're redoing some of those. Most of the time, it's really great. It's usually not the communities hating the laws. It's usually getting Canada to respect our laws. That tends to be the bigger challenge.
Hmm.
Um, just to let you know, there is in the chat from communications. That's the One Feather link if you wanted to vote online, and then the official voting day is Saturday. One Feather is the organization. Sorry, I'm just trying to copy and paste something into the chat for you. One Feather is the organization undertaking the vote, so I don't deal with the
So that's a
votes.
big business for you. That's a really big business for you.
Which one?
When you're in being a lawyer and coming nation to nation and creating laws for them. I can tell you right now there's a lot of controversy over it. I'm sure you must have read it or see it. Are you part of any of the Facebook chat groups that they have?
Yes, I've definitely seen conflicting approaches to laws, and I'm trying to get the
Dog is
official
different, special.
voting day. Honestly, is one of my favorite communities to work with. I love the um, I'm going to say it's multifaceted. You guys have a really thick history, like most communities, but I think your relationship with Oka and Quebec is very distinct, and so it's a community I really enjoy working with. I also think you guys have a lot of really great vocal members, and that's important.
What's your firm called?
First People's Law.
First People's Law. Okay. Do you have an email?
Yeah, I'll drop my email in the chat, link to the website if you want to check it out.
Yep.
I'm just typing.
So
And
tonight,
you
sorry, tonight's meeting, what is it? Just like update on getting ready to vote? Because it was like I was under the impression that there was a vote taking place today, but it's not.
No, well, the online vote is already active, so you can go and register online to vote, but the official voting day in person is Saturday. So this was our last presentation that we gave talking about the laws. The last hour and a half was recorded as well, so that will be available for you, Josh, to watch if you want to hear more specifically about the individual laws. But
Perfect. Have you met with anybody in the community besides the chief and council?
Yes, we've had a number of both in-person and online workshops. These draft laws have been in place since, let me pull up my timeline here. We shared the draft laws in April, but before that, it's been a full year undergoing the process during the lawmaking process. So in July 2024, we issued a draft lawmaking process, which is the KLMP. I'm sure you've heard lots about it. The KLMP is a standalone law and process that standardizes how laws can be enacted in Kanesatake. And so under the KLMP, we then drafted these 4 laws. They've been shared with community since April. We've had, I think, 3 different virtual meetings, as well as a series of in-person meetings where I've come to community and met with, I've done one-on-one, I've done group workshops. I think there's been a total of around 5 or 6. I then took all that feedback, amended the laws a little bit. The council then decided the best way forward is to do a ratification vote. And Josh, you missed this, but the ratification vote, there are thresholds and standards around. I'm not going to do another elevator pitch about the laws, but you'll be able to rewatch these this presentation. It took about an hour to get through the 4 laws in summary, but you can pull them up online, you can read through them, and please go through and watch these videos. There's quite a few of these videos available. I'm sure you'll be very tired of hearing my voice talk about the same 4 laws, but it's important to understand. So once these draft laws were then shared, we got community feedback through all of those sessions. Chief and council then decided the best way forward was to also require a ratification vote. Under the KLMP, the lawmaking process, there is a standard set for what a vote is required to do, to move these laws forward. So now we have these 4 laws going to vote. You have the ability to vote on each individual law. Very quickly, the 4 laws are the Code of Ethics law. That law only applies to elected council, so the elected chiefs. It sets a standard for roles and responsibilities. Like they can't make a decision if there's a conflict of interest. They have to, uphold responsibility, accountability, transparency. It's a very simple law that just governs the elected chief and councils and basically says, if you're violating these laws, you then can be fined or removed from the MCK. So really recommend you looking at all of them, but that's a really great one. So if you go to the law vote on Saturday, the ratification vote on Saturday, you have the ability to say yes or no to each individual law. It's not a suite, so that what that means is you don't have to adopt all 4 or say no to all 4. You can say yes or no to whichever ones you think would be best implemented, immediately. Any ones you say no to just require more community consultations. They require more work in the future. There's a threshold standard though, so I do recommend that if any of these laws you're interested in passing, please talk to your fellow members. There must be a vote of at least 20% of the community, and 50% of those who voted plus 1 have to be in favor to passing those laws. So what that means is if there's 15% of your community membership voting and they all say yes to the laws, they still don't pass because they don't meet the 20% requirement for that threshold. So it is a high threshold. So I do encourage, if anyone's really interested in moving these laws forward, to be talking to your families and your community members and getting them out to vote, either in person or online. If you want to stay anonymous, if you feel like you can't get a babysitter to get to the high school to vote, you have the ability to vote online, and it is a rigorous authentication process. So you're able to go to the One Feather website and do that.
Okay. Who's going to be enforcing these laws?
That's a great question. So we have a few different mechanisms.
Can I have a short answer? Thank you. Sorry to be rude, just blunt, but
No, that's okay. So we have an offense section that if you've committed an offense, you'll be tried under the Court of Quebec. And the reason for that being is because it's governed under Part 27 of the Criminal Code under summary convictions. So it is a provincial jurisdiction. So if there is if you've violated the law and then you're being penalized under the law, it would go to the Court of Quebec for enforcement. Until at some point we also have the ability to have our own court system, but right now we don't have our own court system, so it would be enforced by the Court of Quebec.
So you're trying to do like what Akwesasne has?
I can't speak. I'm not an expert with Akwesasne's.
Oh, Akwesasne is a reserve bordering
No,
Ontario and Quebec, and they have like their tribal council, and they have their police force, and they have their longhouse, and they have all the same conflicts everybody else does. So you're going to be sending people to outside courts. far as I know, certain things that are conducted, unless it's like something that is really criminal, like murder, rape, even like speeding violations, depends where they are, then you can be charged. But there's been people that have like been to court off the reserve, and the provinces of Quebec say we have no jurisdiction there, so we can't apply any of our laws, which kind of contradicts them on certain things. So how's that going to be in place?
Well, Akwesasne, so I actually did
Not
live in
just
Akwesasne
Akwesasne, just general.
for a bit. Well,
Just general.
Akwesasne has multi-jurisdictional issues. We're really just dealing with
I'm
Ganagahage
just
law
I'm
and
saying just general, miss.
Quebec
Sorry.
law.
Yeah.
Yeah, no, that's fine. It's through a process of private prosecution. So it would need to be upheld by the Court of Quebec to ensure that, the fines were being paid or if there were to be any imprisonment time. All of these laws only deal with summary convictions. So there's no issues outside of summary convictions at this point. Like you just talked about, some of those were punishable convictions, which look a little bit different.
Okay, thank you.
Yeah, of course. I really recommend watching this video if you have the time. I know an hour is a big chunk of time to commit to, but download those laws, take a read over, talk to your friends and families, and get out to vote if this is of interest to you. Okay. Any last questions? You're very welcome. Thanks so much for the lovely comments in the chat. Wonderful. Well, happy Monday. Thanks for sticking it out with us into the late evening. Bye, everybody.